It's a pleasure to be here today, this evening, to give this talk. I'll stand here, and maybe occasionally I'll slip over there so I don't block the slides that you can all enjoy as I'm giving this talk. I want to thank in advance Julie Cooper, Asaf Lichowski, and Doreen Lustig for really graciously agreeing to prepare remarks, and I look forward to, as you heard, you'll hear a lecture, but we'll also have really a conversation and a roundtable. And I appreciate that. I also want to thank Rachel Klagsberg and Edith Price-Reed at the Minerva Center for making this possible, as well as this wonderful conference, which doesn't stop here. I'll advertise for you. It continues tomorrow with a whole bunch of other discussions based on contemporary scholarship on human rights and international law. So I'm going to get right to it. I'm talking to you about a book, but before I get to the book, I want to talk about the story that I think we usually think about the history of human rights. And usually I would say it goes like this. On December 9th, 1948, the United Nations General Assembly met in Paris at the Palais des Nations, and they adopted the Genocide Convention. The next day, December 10th, right, we're on the 70th anniversary exactly, 1948, the same body approved the Universal Declaration of Human Rights. And in a certain sense, proximity explains causality. The two are linked together, and what is the big event behind all of them? It's the Holocaust, right? There's a version of this story which usually goes, out of the darkest depths of depravity came a new kind of international law. The Genocide Convention would protect peoples from the worst crime of all, mass murder, extinction. The International Bill of Rights, as it was called, or in its initial forms, the Universal Declaration, would formalize certain fundamental human rights. The shared horror of the Holocaust provoked a harmonious chorus of support for these laws. True, the world was very divided in 1948. Everyone knew about the Cold War and about decolonization, the end of empires, especially at the UN. No one could ignore these divisions, and yet there was a sense, as we're often told, that this could be surpassed, at least in theory, at least for a briefest of moments, to allow this new kind of law to be born. This law, this human rights law, as I'll call it, was designed to transcend politics, because politics was the enemy. And the worst kind of politics was extreme nationalism. Nationalism, as everyone knew, led to racism. Racism led to death. This 1948 breakthrough, therefore, represented, as I said, the triumph of a kind of moral universalism over the extremism of political particularism. So the question is, where did the Jews fit into this story? And first and foremost, in most versions of the story, I think, as we tell it, the Jews played the role of the victims, the paradigmatic victims. The newsreel footage of naked Jewish bodies told the world everything it needed to know about why this new kind of human rights law was necessary. The silent images of emaciated, stupefied survivors pricked the world's conscience. Yet not all the Jews looked like this, and not all the Jews remained silent and voiceless. Those who regained their voices quite naturally turned tragedy into cries for global justice. Today, it seems perfectly fitting to us that it was a Polish Jewish refugee, Raphael Lemkin, who dreamed up the word genocide and the idea of a law to ban it. We think of it as very appropriate that another Polish Jewish refugee, Hirsch Lauterpacht, coined the concept of crimes against humanity and the very idea of an international bill of human rights. And we can multiply the examples of these people to go through a kind of roster of Jews who, especially in recent years, have attracted a lot of attention for their contributions to building international human rights. Here's Jacob Robinson, native son of Lithuania. Like Lauterpacht and Lemkin, the two men I just mentioned, he paved a path from a small town shtetl in Eastern Europe to the Nuremberg trials, where he advised the prosecutors, the American prosecutors. And he later helped start the UN Commission on Human Rights and the International Refugee Convention. Here's René Cassin, the French Jew, who's often credited as the main author or one of the main co-authors of the Universal Declaration of Human Rights. His very name has been refashioned into a kind of emblem of Holocaust-inspired human rights, and that's exemplified by the fact that you have this group, René Cassin, the Jewish Voice for Human Rights, a European human rights organization. I checked yesterday, and technically there's a URL to an Israeli branch of it, but it seems to be misdirected. So I don't know what that means. But René Cassin is another person who gets a lot of attention. And the slogan of this organization, which literally takes two parts, his two names, and puts them together, is right here. Human rights laws were developed to ensure that the horrors of the Holocaust could never happen again. So in a certain sense, this tells us everything that we need to know about human rights, the Holocaust, and the Jewish connection to it. But wait, this is 1948, this is 2018, there's the other big story about Jews, right, which is the birth of the State of Israel. And what did that have to do with human rights? So according to most versions of the story that we tell and we hear again, the answer is very simple. There's no connection, right? The creation of Israel might have been a great exercise in historical justice, but it arrived only in response to a very narrow, contingent situation. After the Holocaust, so the story often goes, justice required that the Jews get a home. The founding of Israel, in that sense, was a form of moral restitution. Making Israel may have helped the Jews, but it couldn't be said to have helped the world at large, because it was about one group, one people. Human rights and genocide, by contrast, formed what René Cassin, that organization I just mentioned, called the truer legacy of the Holocaust. Because of what happened to the Jews in the past, they deserved, or might deserve, a state of their own. Because of what might happen to humanity in the future, the world needed human rights. So when it comes to 1948, most people imagine that the coincidence of the creation of Israel and the emergence of a new international human rights regime is just that, a coincidence. Or perhaps some people say it's a terrible case of irony, or perhaps people now say it's a case of Jewish hypocrisy. And you hear this argument, I don't have to lay it out, it's an argument you hear everywhere, which is, how could Jews have promoted human rights and denounced genocide in Europe, even as they engaged in this war and inflicted violence and injustice on the Arabs in Palestine? So most people answer that question very simply, and they say that 1948 was about two different groups of Jews, right? Jews never agree, and there are these heroic individuals that you've heard me talk about for a few minutes, who are the ones who go for the global dream, and then there are others who choose Zionism and choose nation-state. Another way of putting this is to say that some Jews choose the protection and security of nationalism and sovereignty, and others place their trust in the ideal of legal internationalism. Or to put it very crudely, some Jews choose land and guns, and others choose law and human rights. Or, in another form, some Jews choose the universalism of international law, while others choose the particularism of the nation. So I'm laying this out here because I think, in a nutshell, that's a story that we hear again and again about Jews and human rights. But as I'm going to argue, and I argue in the book I'm talking to you about, this is a myth, and I call it the myth of Jewish cosmopolitanism. Now, there are many forms of this myth, and some of them have actually come back into the news very recently. The far left has a kind of Marxist version of this that's inherited from Soviet times, which is Jews as rootless, capitalist cosmopolitans. And the far right has a fascist version of this, which is Jews as Judeo-Bolshevik cosmopolitans. And as extremes often do, they go so far that they come back around and meet. And that's why we can see certain images being deployed in the far right and the far left across Europe and elsewhere today. But it turns out that liberal internationalists also have a version of this myth. And in this myth, Jews are kind of natural liberal cosmopolitans, except when they end up with a political movement and with the state. The liberal version of this myth, I say, mistakes Jewish mobility for rootlessness and exalts exile as a kind of morally superior position against and in distinction to blood and soil nationhood. It presumes that some, at least some Jews, built international human rights as a universalist alternative to the particularist political project of the 20th century, which was the nation state. So what I want to do today is I want to talk about how that myth, and you'll hear me say more about it, how it operates in the lives of these two men, who are two great icons, about which I'll say more, in the history of human rights today, Lauterpacht and Lemke. And in the process, I want to argue three basic things. First, on a basic empirical level, to get the story right, we can't understand the development of these men's legal thought and the thinking that went into building international human rights without recovering their Jewish politics. Second, writing Jewish politics back into the story of human rights history can reveal the underlying political imperatives that shape human rights law. It can also reveal something that we could call the anti-political legalism that shaped and shapes so much of human rights today. Third, beyond recovering the past and contextualizing the present, a Jewish human rights history can provide a rich inventory of possibilities for the future of human rights law. What do I mean by that? We're in a moment today, and we discussed this some, I'll just gesture back to the conference we had today, in which there's much discussion about the success and the crisis of human rights. On the one hand, human rights language, discourse, norms has spread so far that it can be used by a staggering variety of groups in society. And yet there's also a sense of a crisis about the law of human rights. Neoliberalism debates, of which there are many today, have raised these questions about whether human rights is powerless in the face of global economics, economic trends, inequality. The neocolonialism debates have revealed hard questions about whether human rights law replicates global power asymmetries and the unevenness of post-colonial sovereignty. I simply mean by that, a good example is the debates that African nation states now raise about the ICC, that is disproportionate in how it approaches meting out global justice. And the neopopulism debates have suggested that human rights law cannot constrain the force of the new sovereigntism and the new populism, anti-democracy. One way or another, all these debates come back to the basic question about the relationship between law and politics, and between nations and states and the global order. So all the more reason, I'm going to argue, to go back to this moment 70 years ago and then look at it through Jewish eyes and see how these tensions and questions played out back then before jumping back to think about where we arrived at today. So, I'm going to start with Lauterbach. Today, for those of you who are coming into this lecture don't know anything about him, Hirsch Lauterbach is kind of a hero du jour for many in international human rights law. He's considered the founding father of international human rights law. He's been lauded as the greatest international lawyer of the 20th century. Lauterbach, as you may know, is the man who coined the term crimes against humanity, came up with much of the basically conceptual building blocks of an international human rights law by breaking the idea of a sovereign mold and elevating this idea that individuals could have rights that could be protected above the heads of their nations or through them. And after World War II, he designed the Nuremberg Charter, advised the International Law Commission, and influenced the European Convention on Human Rights. Now, this isn't sort of me as the author or the scholar trotting him out. Many people have talked about him recently, including 2 Yale law professors who recently wrote a book saying he is the single most important man in the creation of the entire modern liberal order. They say there was Grotius a few hundred years ago, and then there was Lauterbach, who gave us our order. If we still have it or not, I don't know. But that's the point, right? He's considered this kind of iconic person who symbolizes something about the ideals of human rights. So the question is, where did he get his ideas? Most people who answer that question basically reference in one way or not the Holocaust and this idea that he invented these ideas about human rights law because he himself was a refugee who fled Eastern Europe, watched as most of his family was killed by the Nazis, and he rose up to a distinguished position in Cambridge, the University of Cambridge, chaired position in international law, and then a judgeship on the International Court of Justice. And the way it's explained is very simple. Because he had no state of his own, he thought beyond the state to fight for all of humanity. Because he had been ravaged by racial nationalism in Europe, he reached beyond it to envision a new kind of legal internationalism. And because he was Jewish, he naturally gravitated towards universal or sometimes European or sometimes Western values. And there's a lot of slippages there. But he left behind the collectivity to think bigger. The problem with this account of Lauterbach is very simple. I would put it simply and say it's not true. It just doesn't match the facts. So a few years ago, I went, as I was researching this book, to Cambridge to visit with his son, Eli Lauterbach, known probably to some people in this room as a very distinguished international lawyer in his own right. So he had already written a whole book about his father, and he discussed his father's interest in Jewish affairs and even in Zionism, but pretty much dismissed it as kind of youthful dalliance. You know, who wasn't interested in politics in Eastern Europe in the 1910s and 1920s? And I said, but there must be more to the story because there's these hints out there. And he said, I don't know if there is, but you can go look in the closet. And then he did what people are entitled to do when they're in their 80s, which is say, I'm going to take a nap. So he went to take his nap, and I went in the closet, and in the closet, there were his politics, right? Because in the closet was a whole bunch of writings of Lauterpacht that, to me, immediately suggested there's much more to this person and how he's developing his legal ideas. So I did what many of us in this room do, which is I whipped out my cell phone and started snapping pictures as quickly as I could to make sure I had these documents. What emerges from this set of materials and others is that the man who invented much of human rights law in 1948 also drafted his version of the Israeli Declaration of Independence the same year. The man who spent a long time thinking about international law and worked on the idea of an international bill of human rights also spent 2 decades contributing Zionist political commentary to a Polish Jewish newspaper. And the man who revised our notions of war crimes, right, and gave us much of our basic ideas about the concept that superior orders could not be a justifiable defense. You can't defend yourself as a soldier just by saying they told me to do it. Advised the Jewish Agency and the Zionist movement for 2 decades on their conflict in Palestine, as well as even in 1948 on the laws of war and what to do in the Arab-Israeli war that will happen. Now, more striking, and the argument in the book is that if you begin to look at his writings, it turns out that he wasn't an internationalist in spite of this kind of interest and commitment to Jewish affairs and Jewish nationalism, but he was interested in international rights because of his politics. Let me explain a little bit about what that means. The starting point for his legal thinking was what we could call national minority rights. After World War I, international law tried to extend legal protection for minority groups via the system of minorities treaties and the League of Nations. In the same spirit, Lauterpacht's goal was to protect Jews and other national minorities in the eastern borderlands of Europe. And that's why his first piece of legal writing is actually a manifesto written in the immediate aftermath of a pogrom, violent attack in 1918 in Lemberg, aka Aviv, where he was living, in which he responded not by demanding equality for the Jews or an end to discrimination or an end to violence, but simply by saying the Polish government must give us our own schools, the right to use our own languages, collective group rights for the Jewish nation. Now, this move on the part of Lauterpacht is as crucial as it's forgotten, because what it suggests is he began to think about international law and think about what we would call human rights today through the prism of national rights and national autonomy. And it's a whole project that is well known, was well known at the time, but isn't often necessarily linked at all to him or to the development of international legal thinking about rights. Now, what's striking about this is, and this is just a picture of a protest in London, the Zionist protest for Jewish rights in Poland. What's striking about this is, in his writing, he sees this as a combination of individual and group rights. The two go together. And this is the first of the kind of dichotomies that I want to push back against and say they're not really a dichotomy in his thinking. They go together because to protect the individual, you have to give the individual the rights to use her language, you have to give the individual the protections for a vulnerable minority culture and so on and so forth. But that doesn't matter if you don't also have equality before the law. And these things are coursing through his early writings. From there, Lauterpacht thinks outwards into the world of international law, and he does it in 2 directions at once. On the one hand, he begins to develop ideas in the 20s of minority rights and protecting Jews as a group. And on the other hand, he begins to talk about national self-determination for Jews. Where? Here. The two form the 2 sides of the same coin. The idea of Jews as a nation, as a collective body that needs to be protected in this world of Eastern Europe, and it also needs to have a grounding in a territorial homeland in Palestine. And again in his writing, you see this move outwards from thinking about what it takes to protect Jews to thinking about a notion of international law and an ordering of the world. This is why in fact, the first piece of published writing he does is a defense of the Balfour Declaration and the League of Nations mandate for Palestine, in which he basically argues that the fact that the British grabbed this land from the Turks and then didn't just make it part of the British Empire, but pulled back and promised it in part to the Jews, was a step forward for international law and for Jewish rights. It gave Jews something they wanted and needed, and it showed that there was something other than just power in the world, that there could be other forms of justice. And this is why, going on, he continues to try and blend or link together what I would call the particular and the universal. In the early 1940s, he writes about crimes against the Jewish people, and then he kind of blends that into the notion of crimes against humanity. And finally, in 1948, he spends the year working to draft a version of the Israeli Declaration of Independence, working to codify international law, working to still push forward his view about human rights, and taking a pause to actually address the question of the legality of the partition of Palestine and what Israel should do in July 1948 when they are facing real legal questions about Arab claims against the partition, about the war itself. He does both of these things together. Now, these intertwined aspects of Lauterpacht's thought basically been forgotten. And I'm not going to stand here and pretend they've never been observed, but when they have been talked about, they've been interpreted as fundamental contradictions between the cosmopolitan side of him and the Zionist side of him. Right? Or he was a split personality. Or early in his life he thought about this, but later on he left that behind. Or he couldn't really, for emotional reasons let go of the idea of Israel, but really his larger goal, larger love was humanity. The argument I make is that that's not true. They were linked together. And they're so linked together that they're basically co-constitutive of his view of international law and human rights. Why? Because basically the goal was to reorder the world, which meant both choosing sovereignty as a necessary device to protect people and seeking to reform it. The starting point for his thinking was one which was actually very common to Zionist thinking back then, which is that no one imagines the Jews are going to empty out of Europe. Right? Herzl doesn't, Chaim doesn't, Jabotinsky, no one imagines that. What they imagine is the Jews will have some kind of collectivity and some kind of homeland. What that will look like, they argue, just as people argue today, and what that should look like, they argue about. But the idea is there's still going to be a Jewish diaspora out there, and there's going to be a Jewish homeland. And the question is how to link the two. And this is where Lauterpacht begins to think that they two can go together, and international law can protect Jewish rights, and then can protect rights as a whole. Now, I could go on with this, but for the sake of giving you a kind of sense of this whole argument, and for the sake of time, I'm going to move on and talk about Lemkin convenience. And then I'm going to jump back and talk about what happened in 1948 and why we don't know the story. So Raphael Lemkin is a person who follows a remarkably similar path from Eastern Europe, Polish Eastern Europe, to the university in the same city as Lauterpacht, Lemberg, Lviv, Lvov, and then to a career in international law and a role at the Nuremberg trials and beyond. As I said, and as you may know, probably know, he gets the Genocide Convention as his life's mission to put forward this new law. For our purposes here, what's important and striking is how much he moves through a similar channel of East European Zionist politics. Indeed, it was his nationalism and his concern for collective group experience and ideas about how to protect it that proves crucial to his vision about law and genocide. Here again, Lemkin's political past has been alternately effaced or overlooked by scholars who have actually asked many times, where did he get his ideas about law from? What sparked his legal imagination? It's typically been explained as either a kind of cosmopolitan Jewish socialism or an apolitical flight into justice, leaving behind the messiness of politics, or that it has something to do with just a generic kind of anti-Semitism, or this idea, which comes through actually in his own writings, that he was just, even as a child, he just had a natural moral empathy. He was thinking about atrocity and mass murder as a child. And then it happened to him and his community. And so naturally he began to think bigger and think towards genocide. It turns out that he also spent several decades as a Zionist leader. In this case, he was associated with the General Zionist Movement, which is, where's the center? It's gone. But the general Zionist movement was an incredibly important part of East European Jewish politics, and many of the lawyers that I talk about in this story, really that was their version of Zionism. Why is this important? Because it turns out that he spends the 20s and 30s writing in Yiddish and Hebrew and Polish, and writing actively and thinking about what it means to talk about a Jewish nation and its political goals, and then thinking about the legal challenges that it faces to survive. This, for those of you who are close enough to see and read the Hebrew, this is he wrote on the occasion of the opening of the Hebrew University in 1925 about the sin that we've neglected our language. It's a very kind of classic Hebrew national manifesto for our language. This is about, in Polish, writing to youth Zionism and the youth movement, and what youth have to do to fulfill the mission and mandate of Zionism. And here he is, it's hard to see, but he's up in the top corner with the editors of Heint, the Yiddish daily newspaper for which he wrote for about 12 years. So what was he doing when he was writing? First and foremost, he's writing about Jewish rights, and like Lauterpacht, he's writing about minority rights, and his greatest goal is to fulfill the ideal that the Jews could have a collective status in Poland that would protect them, and it would be called the Kehillah. People today, even historians, associate the Kehillah as kind of like an artifact of pre-modern Jewish life, a kahal, but for him it is the communal structure that allows for Jews to run their own schools, to have their own courts, even their own tax system, and to protect themselves economically, culturally, linguistically, and so on and so forth. So here he is, he's an advice columnist in the Yiddish newspaper for about 7 years. Here he is writing about the ideal of a Jewish communal framework, which would be a collectivist rights framework. And here he is as a feminist column, defending women's rights and Jewish rights, and talking about the long history of Jewish feminists, female feminists, in Western Europe and then in Eastern Europe, and how this is also linked to the national struggle for Jewish rights. So the point isn't just that he cared about these things, the point is that they came together to define what I say is his political worldview. And that worldview, I put a name on it, and I call it Zionist internationalism. It wasn't that he didn't want a state in Palestine. He, in fact, went much further than Lauterpacht in saying, already in the 20s, we need a nation state. It wasn't that he didn't think about that state as something which was going to define Jewish nationhood and nationalism, but it's that that went in hand with this goal to protect Jewish minorityhood in the diaspora. And this is why he spends lots of time in these early years writing and thinking out loud about the threats of what he calls assimilation and acculturation, that Jews can lose themselves as much through the kind of soft pogrom of Polish legal persecution as they can from losing their language. And this is why he calls on people to learn Hebrew, even as he writes in, as you can see here, Yiddish and Polish, because this will kind of bolster the identity of his people. This is also the position from which he begins to think about justice. In a book project that emerged from the book I'm talking to you about, I go looking for where he begins to think first and foremost about violence and how to respond to violence. And I argue that basically the trial of Sholem Schwarzbard, who was a Ukrainian Jew who assassinated a Ukrainian nationalist leader in Paris in the mid-20s and was put on trial for it, was the turning point. We now know that Lemkin attended the trial and covered it for the newspaper. And he wrote about it because here was an instance of someone pursuing international justice on behalf of his nation. And Lemkin actually argues that Schwarzbard should be considered innocent because he didn't kill a man. He created a necessary moral act of revenge because there was no other mechanism in international law to defend his people and the crime and suffering that they had suffered. And so he actually makes this very interesting move from talking about Jewish revenge in 1927 to talking about barbarism and vandalism and attacks against the physical and spiritual character of groups. And he really has both Poland and Germany in mind, although it's interpreted more as against Germany, and to finally, in the middle of 1944, coining the term genocide, as we know. So what I think we begin to see here is that this is a whole story of a pattern of people moving through political activism, which is often intertwined with international legal thinking, and experimenting with what it is to protect Jews as a minority, and imagining new ideas, and then making moves that take them, therefore, into the realm of thinking about new ideas, such as crimes against humanity or genocide. So, you might ask by now, as many people have already asked me, so what happened to this, right? And why don't we know about it? And the simplest answer is that 1948, right? But not 1948 in the way that I think most people imagine. Both Lemkin and Lauterpacht reacted with great disappointment to what happened in 1948 in terms of human rights. Now, sometimes this is explained in terms of the fact that, well, that's because Lemkin thought that human rights was going to undermine his quest to have this genocide idea, and Lauterpacht kind of poo-pooed that because he said the individual is more important. There's really not much evidence for that. What really seems to be animating them is that both have a disappointment that the architecture of the human rights system being built at the UN is weak, has no real implementation, has no real enforcement, and it has uneven power distribution. Both men feared that great power recalcitrance would undermine human rights. Both also feared that politics would undermine human rights. And here's a quote, two quotes actually, from Lauterpacht, in which he begins to condemn what's happening at the UN, even though he's been involved in shaping it, but he criticizes it because he says it is very susceptible to politicization. What does he want? He wants a binding legal system that will make all states behave properly and all states obligated to respect these human rights. And then we can begin to expand the names of those rights and what they are. Instead, he says, there's kind of just a lot of discourse and norms, but we don't have enough hard law. And this makes it susceptible to politics. Now, the fact that Lauterpacht and also Lemkin feared politicization of these ideals and norms and nascent laws did not mean that they stopped their own political commitments. Both continued to identify as Zionists after 1948. This is true for Lauterpacht, and this is true for Lemkin. We now know that Lemkin himself corresponded with people as diverse as Chaim Weizmann, Hillel Kook, Moshe Smeh, for those of you following Israeli political history. He was considered for a job in international law at Hebrew University, and one reason was because he was said to have had a beautiful Sephardic Hebrew accent. But more importantly, in 1952, he published the first version of his memoir, his autobiography, in Haboker, in which he describes the first genocide in history as that of the destruction of the temple in the year 70 by the Romans. This was the first genocide because it was not only a physical destruction of property, but it was also an assault that went beyond a military campaign to a targeting of civilians. And then he goes on very quickly to say, and then the Roman attack on the Christians was also a genocide. So he has a narrative of this which he decides to present early on in Hebrew. This is not the only article he writes in the Israeli Hebrew press. So the politics continue in that sense. But both of these men make a striking decision to conceal their politics in other ways. So both of these men begin to basically downplay publicly their involvement in Jewish affairs or the Zionist movement. So Lemkin writes in Hebrew here, but basically when he goes around in the late 1940s and the 1950s to try and build support at the UN for his project of a genocide convention, he no longer mentions Zionism. He no longer mentions his political principles. He no longer mentions that. And he takes steps actually to conceal it, which is why this is actually something he doesn't mention. It's not well known. And in fact, when he writes his autobiography in English, he doesn't mention his Zionism. He says it was basically the Roman massacre of the ancient Christians that inspired him at first. And then it was the Armenian genocide. I don't think those are necessarily wrong, that it doesn't have to be, it was just the Zionism, right? But it's striking that he has a different version of where he's thinking, where his imagination is coming from. What else is happening? A couple other important things. I think that Lauterpacht and Lemkin in 1948 and afterwards begin to realize that there is a world of states, a world of sovereign states, and it's very clear that the idea, just as you hear today, of dual loyalties might impede their careers. So in other words, Lauterpacht famously takes steps to conceal the work he did for the Zionist movement. He doesn't want that known. And he says, I've got nothing to be ashamed about, but it's better if we just put that away. Because he says politics will only will discredit the work we're trying to do as lawyers now. More critically, both of these men saw the utility of a myth, I think, of a liberal cosmopolitanism, which is to say that we're Jews who did this work, and we didn't have parochial attachments. We did this because we were victims, but we didn't do this because we had ideological commitments that also shaped what our victimhood and what our experience meant. To become symbols of universal suffering required snipping some ties to the nation in that sense. But there's one other thing that I think also contributes to this, and this may be the thing that I think gets the least attention. That's tomorrow, which is December 11th, the third day in December. After the 9th and 10th, after these dramatic things, comes the United Nations General Assembly debate, which produces Resolution 194, which is about the war here, right? It's about Palestinian refugees. The very same people who were busy drafting and debating human rights and genocide for weeks and months beforehand are also debating the war here, because it is literally the same people involved in the story, arguing. Many Arab diplomats, René Cassin, indirectly Lauterpacht, and indirectly Lemkin. And so it's not hard to understand that this made it even harder to bring a political commitment such as Zionism into the conversation about where human rights came from or what they should be. Because this was an unresolved problem, and this was a political bomb, so to speak, just as it is today, and when we think about the debates on human rights and law. This image of 3 days, human rights, genocide, and Palestinian refugees, shows how complicated things became for Zionist lawyers after 1948. But I want to make one other point before I transition to some larger thoughts about the forgetting of this story and what it could mean for us today. And that is, if you just look at this and you say, oh, of course, Zionism, it wouldn't work anymore, so they had to kind of downplay it. You miss, I think, a truth that is larger, and that was certainly true for Lauterpacht and Lemkin at this moment in time. And that is, they came to realize that the challenge was, this was all designed for a world of sovereign states. And one of the interesting questions is, why did they begin to let go of minority rights and all these other creative ideas that we know they were thinking about? Why does Lemkin let go of things such as cultural genocide, more expansive ideas of what the law could be? And the answer is, he sees the politics, as I mentioned, but he also sees that the world is shrinking down into a world of states. And the problem, of course, is that not everybody has a state. It's not just the Palestinians. There's still statelessness in the world. And there's still this basic issue about, will the world be fully completed? One way to think about this is to think about it in terms of partitions. Like the partition of Palestine fails, and everybody talks about it, and everybody argues about why and how, but we know it failed. And the partition that these lawyers dreamed of between law and politics also fails in 1948, because they are not built separately enough. And in a certain sense, I think this means that human rights gets trapped between law and politics at this moment, at least in the way that they understand it. So, turning to today, it's one thing for me to come and to argue that this is this important part of the story that's been forgotten, and that it's forgotten because they took steps to depoliticize themselves and to hide the sources of their legal imagination. But it's another to explain why they hid it and why it succeeded at being hid so well. Right? Why did the rest of the world forget this so quickly? And I want to talk for a second about this, because I think this has less to do with Jewish history or Zionism or 1948, and more with the conditions of the more recent world that we live in, which is the world of liberal internationalism at the end of the Cold War. So I want to, in closing, turn to that question, because I think if we reckon with this, it can open up a larger discussion about thinking about human rights history and law itself. One of the achievements of the end of the Cold War liberal order, if you will, was to elevate human rights into a new post-Cold War ideology. With global democracy on the rise, the West needed a way to reimagine its past. And this is also the moment in which Holocaust memory really surged to the forefront of being directly linked to the idea of human rights, that the two rose together and were intimately connected, as well as genocide connected to it. What happened at that moment, I think, to make a long, complicated theory short and hopefully simpler, is that human rights needs a usable past to explain itself to the world then. And that past comes to be linked to the Holocaust. And it also, human rights has to be kind of a technocratic, liberal ideal that is not going to be political. And so the thing that seems to happen at this moment is, even though there's this surge of new interest, particularly in Lemkin, it does not translate into excavating anything having to do with its actual life before World War II. It just turns into his kind of selfless ideal because we know the story. The story was he was a Holocaust refugee / survivor / witness who came up with this ideal. What this meant is that the human rights activism of these men came to be seen as of a piece with their generic liberalism, their experience of anti-Semitism, their cosmopolitanism, and their experience of the Holocaust. But what didn't seem to fit or even to be necessary was this idea of nationalism. Why would nationalism be relevant to this? We know what the story is. It simply didn't fit the needs or the logic of that moment. And I think this is the moment where you really see this trend begin, which spirals and spirals, of, well, of course Jews are interested in human rights because they're always the prototypical victims. We know that Jewish history then and now is not so simple. So, moving a little quickly, let me turn finally to the question of today. This is a moment of crisis for liberal internationalism, and there's an interesting thing. If I've just told you that in the 1990s and the 2000s, there's the beginning of this romanticization of Jews and human rights because of the political needs of the moment. So what kind of past do we need today? And I want to close by addressing that. Today, human rights law is held up in many quarters as like the last refuge of liberal defense against the illiberal politics sweeping the globe. But its defenders must grapple with the charge that human rights law is, some have said, powerless or even complicit in some of today's challenges. What's striking is that those who think through these things still seem to succumb to a set of mental binaries, that the whole point of this story is to try and challenge cosmopolitanism and tribalism, sovereignty and transnationalism, nationalism and internationalism. And I don't think it's surprising that in this moment, Jews have been reinscribed into the global leftist and rightist imaginations as symbols of extreme nationalism and ruthless cosmopolitanism, because it's a bifurcation and a reassertion of that. So what does that mean for all this complicated history? Because of that, I want to suggest that recovering the presence of Jewish politics, how much politics went into making human rights, can speak to the polarization between Zionism and human rights that's overtaken certainly Israeli political culture and the human rights movement. This is not going to exculpate anybody. This is not going to solve any contemporary questions, but it will allow us to see the past in more of its complexity, its contingency, its contradiction, and it can remind us that a monochromatic ideological demonization of the past or the present, whether it's national self-determination for Jews, for Palestinians, is kind of a cul-de-sac, which is more of a fantasy, I think, than a place from which to begin creative legal thought. That's a little normative, I know. But second, acknowledging the absence of Jewish politics from current human rights history can reveal something about where human rights law comes from and its blind spots. Where it can demonstrate that our fantasy of legalism, that the law can be completely untainted and disconnected from politics, is itself a myth that appears from a very specific set of circumstances. It leaves its imprint on it even when we don't see it. And what we have to grapple with is much more the reality of a paradox, that law is built out of politics, but then has to separate from politics. But pretending there are no politics isn't going to help us. This in turn takes me to my third point. Beyond historical correctives and political interventions, retrieving this type of history can address some crucial problems in thinking about how to imagine the future of human rights as law. And this is the last thing I want to speak about this evening. Contemporary international human rights law centers on a model of cosmopolitanism that leaves very little room for collectivities, for groups beyond individuals and states. Of the space between the individual and the state, the groups within and beyond the state, human rights law has surprisingly little to say. Groups, nations, and ethnicities can realize their rights through self-determination or as individual rights bearers, but the post-war shift away from this kind of group rights left law unable to confront many of the issues that precisely confront us so much today. Recovering these roads, these earlier things that seem to defy our sense of binaries, individual, group, nation, state, territory, diaspora, gives us a set of options to think about what law could be. And part of the challenge is to think about this in terms of shapes. Because law doesn't really like shapes, right? Law likes to generalize and make things standard and uniform. And law doesn't like the specificity of cultures that don't fit neatly into boxes. I think this is what Lemke and Lauterpacht were basically wrestling with in 1948. And their answers and their silences and evasions are the things we should start by looking at today. And I also want to suggest perhaps there's a role for history to play in this moment in thinking about finally the last big thing, which is particularism and universalism. And so to end, I want to share with you the image that I used for the title of tonight's talk, which comes from a lecture given by the American Jewish writer Cynthia Ozick in 1970 in Israel. Speaking of the fate of the Jews as a diasporic people, she addressed this challenge about particularism and universalism and survival. And Ozick says that the shofar, the ram's horn, which turns into this vessel of holy sound, is a perfect metaphor for what I'm calling rooted cosmopolitanism. If we blow into the narrow end of the shofar, we'll be heard far, she says. But if we choose to be mankind rather than Jewish and blow into the wider part, we'll not be heard at all. Now, it's not a perfect image, because if you note, she's still repeating the same dichotomy, right? Jewish, mankind, right? Particularly universal. But I think she's making an interesting and important larger point about the sources of creativity and the movement between the particular and the universal. From the emotional expression of a particular culture comes an idea that expands to fill the world. Blowing the shofar from narrow to wide gives voice to something at once human and distinctive that expands over distance to reach farther and wide. And we could think about this maybe in terms of law. The shofar is cacophonous, right? It doesn't have the smooth glide of other instruments, the clarinet, the sharpness of a trumpet. It's raw and uneven. It's not really a musical instrument. And for anyone here who's ever heard it, it's not necessarily a pleasant thing to do, especially when you hear more than one together, right? Because they don't harmonize. They don't actually fit, just like this picture, right? There's no template, even though I've learned recently China is putting them out by the thousands, which is another story. Or maybe it's the same one. But what I think is interesting as a way to end with this and think about law and sound is that this is kind of an impossible quest, right, to harmonize the heterophonic, right, to blend these different sounds to something that can fit. But maybe that's a good metaphor for thinking about international law and human rights law at this point in time. So I'll leave you with these questions. Can the law be like sound? Can it make us listen even when it jars us? And can it fuse the many into the one without dissolving the differences that we all recognize as a part of humanity? And finally, can it link the past and the present together to bridge the distance that we want to go into the future?